We're going to turn to a lighter note now. Bill Hubbard is a trial lawyer with Thompson Hine in Cleveland, Ohio. With all of the social media information that people are posting, a wealth of information is now available about parties, witnesses, and even jurors that previously was more of a mystery. Bill will discuss best practices for ferreting out information and getting it admitted at trial. Please welcome Bill Hubbard.
Actually, I'm here to tell you if you commit corporate wrongdoing, do not talk about it on Facebook. So just real quickly, the next couple of minutes I'm going to spend talking about publicly available social media, private social media, best discovery practices to ferret out those things, authentication, evidentiary issues that you face with social media, and social media and jurors. So when we talk about social media, we're talking about any platform by which people post pictures or videos or just their thoughts online, including Facebook, Twitter, LinkedIn, Google+, YouTube, Flickr, MySpace, MyLife, whatever it is. More and more Americans are using these services or using these sites. 58% of US adults have a Facebook page. 70% of them check it daily. 45% check it a couple times per day. 10 of you will check it while I'm talking, so which is fine. Just be nice what you post. But we know more and more people are posting information. Facebook especially is becoming more entwined in people's everyday lives because you can purchase things directly through Facebook. You don't have to leave Facebook. You can download and read articles now through Facebook. So we know more and more people are using and recording their day-to-day activities through Facebook. There's also wearable devices. We have everything from Fitbits to Apple Watches to GoPro, both scuba divers and drones. There's a recent case where a fitness instructor tried to, she claimed personal injury and that she was no longer as active as she was, and she attempted to get in her Fitbit data to show that she was active before the accident, and then afterwards she was no longer active as reflected in the Fitbit. You can see on the defense side, using the same information, getting someone's Fitbit data and to show that they are just as active prior to the accident as they were after. Their sleeping patterns haven't changed, everything like that. GoPro, I'm sure most of you have seen. Every day it seems like there's footage on the internet of a car accident. A lot of motorcyclists now wear GoPros for safety. And so I think it's just a matter of time before we see actual video footage of accidents and other incidents. The easiest way to find social media, public social media, is simply through a Google search, through as much identifying information as you can have for the party or for the plaintiff. Google searches, Bing searches, LinkedIn searches, Facebook. You see, I've circled my wife's name because I don't have a Facebook page, but I stalk people through hers. I think I know more about the inner circle of the moms in my community than I probably should. Collecting data. The most important thing is trying to balance what's out there between what's useful. So we think it's a best practice. What we've done is make internet search for your plaintiffs or your parties and witnesses just standard operating procedure. Have an associate do it or a paralegal. Just kind of see what's out there because some of it may be helpful. Have a standard set of sites that you hit. A lot of vendors will do internet background reports for a flat fee. I think those can be helpful. Sometimes they're a little bit more, there's more information there than you can ever possibly use. So it's rather than risk reward, it's more burden reward. How much are you going to really get out of all that data that they provide you? Hopefully you recognize the picture. That's the last scene from Raiders of the Lost Ark where they're putting away the Ark of the Covenant. So again, it's just needle in the haystack, and you've got to balance the time it takes but there can be very good things in social media. Turning to private information, courts distinguish between public and private information. So on Facebook, most people by now know that you can have private settings on your Facebook account so that only people who are your friends can see that information. I know not all of you out there know that because I've looked at some of your Facebook posts that are not private, and not to embarrass anybody, I didn't want to put anything up, but I've seen people's vacation pictures, people's pictures with their kids playing lacrosse. So if you want to make it private, you can make it private. But amazingly, there's a lot of people out there who keep their Facebook and their other postings public, and that you can see those. This is, hopefully everyone knows this by now. Do not friend a witness or represented party. It's common sense. It's the same as you can't go out and talk to a plaintiff. You can't go out and hire a private investigator and have the PI talk directly to the plaintiff. There's a lot of ethics opinions about it. Some go as far as to say you shouldn't even friend a witness because it goes against the ethical requirement that you do not deceive anyone. And so if you're friending a witness and you're not being honest about them while you're friending them, it's deception. And the same, the Philadelphia Bar Association has come out and said for the same thing, you can't have a third party friend a witness. Because again, it goes against the deception issue. LinkedIn is an easy, I think probably almost everybody in this room, if not everybody in this room, probably has a LinkedIn account. It's a good source to get just background data real quickly on parties or on experts. Just be aware that when you search on LinkedIn, depending on what your settings, people see that you are searching for them. So if you have your settings to the recommended standard default, then when you're searching for people, people can see that you are searching for them. So some bar associations and ethics committees have said that that's communication with a party, with a representative party, so you need to be careful about that. You can turn your settings to anonymous, but that if you do that, they can't see that you're searching for them, but then you in turn cannot see if people are searching for you. So it's kind of I personally, if I'm looking for something, I turn it to anonymous, do searches, and then turn it back to the default if I need to. So private information, just the fact that someone has a Facebook account, courts do not allow you to go rooting through someone's Facebook account. You have to set up a predicate that there's something in the person's public information or something that you've gotten in discovery that leads you to believe that there will be relevant or potentially admissible evidence in their private social media. And you need to do that to establish the right to get their passwords or other ability to get into their private social media accounts. For example, one case that it was done well was in Zimmerman versus Weiss Markets, where the plaintiff claimed he was injured by a forklift and that his injuries were he mauled his leg and didn't wear shorts, while the defense went out and actually found on his wife's Facebook page pictures of him before the accident where his legs were mangled or injured from a previous motorcycle accident, and also showed pictures of him after the accident with wearing shorts. I had a similar, what kind of got me interested in this was years ago we represented a self-insured client who did a lot of employee car accident cases, and a young woman who had a very uniquely spelled name, first and last name, claimed that she hurt her leg in the accident, and Googled her, found she had a YouTube page, a MySpace page, and a Facebook page, all of which had videos from her dance, her spirit dance team, and her school play and her school musical. So we were able to resolve that amicably. So discovery practice. So knowing that you have to show the court a reason why you need to get their public information. How do you set that up? First, finally, preservation letters. Always on the defense. We've always been on the bad side of ESI, where we've got to produce documents, we've got to preserve ESI. This is a chance for you to turn the tables and have plaintiffs or other parties have some burden to preserve ESI. We had a case, a class action where it was a toxic tort class action where one of the named plaintiffs claimed that the claim was that their property was diminished in value because of exposure or being close to these contaminated sites. And he had a long blogging history about how ranting about the banks and all the foreclosures, and that's the foreclosure crisis that caused the properties in his neighborhood to diminish in value. So it was great, and we were able to, that came out in his depo. We had served a preservation letter beforehand on plaintiff's counsel, came out in his depo. We were able to get an order from the court that they had to do a whole ESI search of his, search terminology of his home computer. So it was, and there's a lot of really good stuff in there. So finally, it's our opportunity to kind of turn the tables on plaintiffs. Discovery from service providers, I don't think it's worth it. They put up a lot of roadblocks and it's difficult. First of all, they have, there's an act, the ECPA says that they cannot provide information, but then with consent, they can. However, even with consent, they're notoriously slow to provide you with the information. I think it's worth spending the time to subpoena them to see what you can get, but I wouldn't count on it. There's more efficient ways to go about getting it. One thing you can do is vendors can set up monitoring mode. If someone's website is someone's posting is public, a vendor can set up a monitoring mode so that they are monitoring the person's Facebook or their other social media postings. So that one of our vendors explained to me he had a case where a gentleman claimed that he had injured his knee in a workplace incident, and he went skiing with his family. He posted pictures of them on their ski vacation, realized, I should not have done that, took it down, but because they were monitoring it, they had that information. If they checked it the day before and checked it the day after, they would not have seen it. But because they were monitoring it, and they knew he was an active Facebook user, so it was worth doing, they were able to record that. Written discovery and depositions, just have a clear checklist of things you ask, smartphone activities, do they log on to Facebook on their phone, where do they access social media, on their computers at home or at work, iPads, what have you. Get all their social media accounts, get information about their blogging activities, whether they have their own blog or where they often appear as a guest blog on other people's blogs. And then web pages where they post comments. Get their users' names, because then when it comes to authenticating it, that's helpful. Collection and preservation. Again, once you get to the point of getting private information, you're going to need a court order unless you have the other side agreement, which is unlikely. But you set up the predicate where you have information either through depositions or discovery or what's publicly available. Get an order from the court to do it. I found that having the vendor do the actual collection is the best for a couple of reasons. First of all, they can collect metadata and hashtags, so it has all the information about when it was posted, what computer was posted from, things like that. I also recommend using a temporary password. Don't have the other side give you the password that they use, because a lot of people, myself included, use the same password or a combination of the same password for a lot of different sites. You don't want to know that. Have them assign a temporary password, have the opposing side assign a temporary password for their sites, give it to the vendor, have the vendor pull the data, tell the other side you've pulled it, and have them change their sites. That way or change their passwords back. That way there's no issue of you having their password or making any changes. The other good thing is that the format collected is more similar to user interface. So if they collect it, they're going to be able to produce TIFF images that look more closely like what it looks like when a user looks at the site. So evidentiary or authentication and evidentiary issues. Again, like most documents and things you want to get in evidence, courts will look at Rule of Evidence 901 and conduct 104 hearings. The law is still developing, but generally there's two requirements. One, does the printout or video or photograph or whatever it is accurately depict the post? And then two, was it authored by the source you claim? So for step one, is the post what you claim it to be? Three easy ways. Have the author himself or herself authenticate it, or have a witness testify that she printed out the post, she recalls the appearance of the printout, and this exhibit is that printout, or that she visited the site, read the information in the printout, remembers the contents of the site, and can identify the printout as accurately reflecting the post. You don't need to call a representative from the social media company. Authentication step two, courts take a totality of the circumstances approach. They look at a lot of different factors, including testimony from the person who created the post, testimony from a forensic computer expert, testimony from a witness with personal knowledge. There's a lot of these, a lot of the case law that's been developing is in the criminal context, so you have a lot of people who are tweeting or posting things about fights or what have you, and a lot of times where it's been excluded is where other people than just the defendant have access to the person's Facebook account or their Twitter handle or whatever it is. Just an example. Courts take the totality of circumstances approach. So Jordan speaks. I was going to use Kim Kardashian's, but I realized do not Google Kim Kardashian at work. So use Jordan Spieth's example. So again, you're looking at the totality of circumstances. Is this likely to be that person's post? And you look at the circumstantial evidence for that. Hearsay, the same. I'm not going to spend time on this, but hearsay, the same issues that we faced before are still here, so you have to deal with hearsay. So social media and jurors, again, same thing. You can't friend jurors. Don't do that. There's a recent report of a survey of federal court judges asking them about their experience, how they treat social media with juries and with attorneys who appear before them. So 26% of federal judges absolutely forbid counsel from conducting social media searches of potential jurors. So just be aware, whatever jurisdiction you're in, be aware if you can do it or not. Those who do it, they tend to do it before voir dire to get an idea of what's going on if they have the jury pool's information. Some people can do it on the fly during voir dire to see if people are posting any information and what their job might be, what their hobbies might be to help inform with jury selection. Again, just use your judgment. Do not be perceived as invading juror privacy. The same judges were asked about their jury instructions, and they say that 96% of federal judges address it. In the beginning of the trial, the juries are directed, do not conduct your own internet searches, do not post about what you're doing, do not blog about the case. That being said, I'm sure everybody has seen in the news where there are jurors who go and they blog about the case and what's going on. So it's important that you look first to see if a juror does do that, what will they see? What will they see if they research the parties, if they research your clients, if they research opposing counsel, just to be aware of what is out there. And then during trial, monitor social media sites and then report any violations. So great, that's the end of my talk. Thank you very much.